Hello, my name is Sebastian Zahadon. In this presentation, we'll go over intellectual property rights in the modern age. The presentation will take a glance on the social, legal, and ethical impacts that have either helped or infringed our role and usage within technology. Let's begin with what is intellectual property. Intellectual property is a right that is had by a person or by a company to have exclusive rights to use its own plans, ideas, or intangible assets without the worry of competition for a specific period of time. The main four uses of intellectual property that will be considered in this presentation will be copyrights, patents, trademarks, and trade secrets. Patent, the most known from the group. A patent is an intellectual property right granted by the government of a nation to an inventor that gives him or her the exclusive right to the invention for up to 20 years in exchange for disclosing the details of the new technology to society for its ultimate benefit. Copyright. Copyright grants the creators of the original work an exclusive legal right to determine whether and under what conditions this original work can be copied. The most famous uses of copyrights have been musical acts, arts, dramas, and anything else that can be considered creative work. The most known uses of copyright have come across several streaming sites such as YouTube. Whenever a song is used in the background, the original creator of the song can put a copyright infringement on it to be taken down and all the royalties to be passed on to them. Trademarks. Trademarks are used to distinguish differences between individual works or businesses. This distinguishing features could either be names, symbols, or anything else. Trademarks lead the global market, creating psychological want and need for certain items with symbols or logos. Some of the most famous companies are pictured behind us. Apple, leading the world in technological innovation and retail. Nike, leading in apparel and clothing. And Starbucks, leading in coffee sales and psychological need and want through social media outlets. The greatest and most broad form of intellectual property rights is trade secrets. Trade secrets in form of business are laws that require intellectual property rights to be protected within the company or certain individuals. These are usually accomplished in the form of non-disclosure agreements, NDAs, which are legal contracts that hold the two in agreement to keep the information confidential. The most recent form of trade secrets has been used between top rival software companies. Whenever their employees leave or terminate their employment there, they sign NDAs at the beginning of their employment that do not allow them to move to rival companies. The earliest usage of property rights. The introduction of property rights began in Europe within the 1500s. Early patent systems reinforced the wealth of elites instead of the welfare and productive capacity of the whole of a society. The price of patent systems sometimes was more than the average biweekly salary of a middle-class citizen. These systems were put in place to restrict the growth of these citizens and to continue the growth of the wealthy. The first English patent for an invention was in 1449 and was granted by Henry VI of England for John of Luton through letter. This is also one of the last moments it was ever used through letter. Patents in the United States. As the first country in the world to incorporate intellectual property rights in its national constitution, America's founding fathers viewed intellectual property rights as vital to the nation's economic survival. They consciously designed the patent system that would do what no patent system had ever done before it: stimulate the inventive genius and entrepreneurial energy of the common man. The patent system created in the United States led to a lot of innovation and increase in technology by the common man. The rise of patents in the United States. With the rise of innovation and technology, the steady increase of patents have continued to increase, most recently reaching up to 500,000 patents in 2016. Up to now in the presentation, we have discussed the advantages and benefits of using intellectual property rights. Now, furtherly, we will discuss the negative connotation that is sometimes brought with intellectual property rights and its usage in the United States and throughout technology. The negative connotation associated with intellectual property. While its advantages outweigh the drawbacks, it's important to note the disadvantages of securing intellectual property rights. The problem with intellectual property rights is that they are unable to own the concept of their ideas. The whole concept of intellectual property stems from physical property. So ideas are tangible objects, when in fact sometimes they are not. Because of this issue, copyright protections can be granted to those who don't really need them. For example, Amazon patented items which are being sold within a white background, which is a prime example of patent frivolity. This leaves many individuals and small businesses susceptible to being attacked at the large end of larger corporations. As you may know, the standard for online shopping in retail is to put the item behind a white background because it makes it easier for them to distinguish it from anything else. If this isn't able to happen, it can lead customers to use Amazon more than their other sites. Intellectual property, the ways it can affect your property. Though your patent may be filed, it's left to yourself to protect it against those trying to steal your ideas in federal court. Patents can be enforced by their owners in U.S. federal courts, but it is up to the owner of the patent, the patentee, to enforce it against infringers by filing a civil case in federal court for patent infringement. It's important to note that patent rights only exclude others from using the patentee's invention. Patent holders have the legal right to exclude others from making, using, selling, or importing the patent invention throughout the United States. Patent infringement occurs regardless of the infringer's lack of knowledge of the patent or their intent to infringe it. In modern times, patent enforcement has become a long and very expensive process. Patent litigation serves a vital function in society by settling the validity and disputed ownership of patent rights so these can be commercialized into new products, services, medical, and treatments. The bottom line is, your invention or product can be used without you knowing, until at one point it reaches a mass market, and at that long, it would take a while for you to fight it legally. Creativity and the manner of reaching it. Lastly, a conversation on the usage of creativity in the modern age. I don't know about you, but when I've always thought about the things that have been invented and the things that are forthcoming, I can't seem to grasp a certain concept that more things can be invented. The great thing about creativity and those who come up with it is the manner in which they
Works
do
may indeed
so.
be kind of like property, but it's property
In the
that we're
video
all building
provided
on.
below,
And
Kirby
creations can only
Ferguson
take
does a
root
TED
and
Talk
grow
in which he
once
goes
that ground
over
has been
how
prepared.
modern day innovators and creators
Henry Ford once said, "I
and all
invented
the things
nothing
that they
new.
do
I
are
simply assembled the
remixes of
discoveries
things
of other
from the
men
past,
behind whom
whether
were
it be
centuries of
song
work."
samples or
Progress
uses in
happens when
technology
all the
from
factors that
certain
make Ford
films
are
and
ready,
movies in the
and
past.
then it is
He explains a
inevitable.
recycling of all the
2007.
material and media.
The iPhone makes its debut.